So I'm Mike Smith. I'm at Oxnard in New Orleans, along with Jeff Quo. Jeff Baker is at University of Louisville, and Marilena DiSilvio and Denise Dickerson are attorneys that we've worked with to do these presentations in the past from Ohio. No disclosures, despite 16 years of trying to get financial conflicts of interest. So why do this? So this sprang out of an experience I got. I got sued for not refilling a Percocet prescription. This was before an affidavit of merit in Ohio. And it's something that we're likely going to experience in emergency medicine. Even if it's something that seems like it's frivolous, it still has an impact on you. And you're at risk for this because we, under EMTALA, we provide this care, so even if it's care that may not be reimbursed, you're still at risk for a lawsuit. And the other thing is that in my residency in Ohio, a lot of people gave advice as the physicians, the attendings would give advice, and then you'd ask them, have you ever been sued? And they hadn't, so they were passing along a lot of information. I thought we would do this training directly with attorneys using simulation. So the way this works is that we take a physician volunteer. So we started doing this with chief residents, but Dr. Quo is a long-term attending at Oxnard. And we give him a case that's been blinded. It's a real case. And we allow him to prepare with the defense attorney, just like he would prepare over a real case. And then we'll do the deposition up here on stage. So you get something like this, and he makes a face like that, then he goes to that. So it's actually, this is there's a little bit of a change. This is going to be a misstroke case. All these cases had a defense verdict. So these are not sort of insurmountable cases that would be settled. They're fairly routine type cases, but they don't feel routine when you're going through them. So we'll get started with this mock deposition. I'll get off the stage for them. So I just ask that you respect the process. I mean, they may say something that's humorous. I mean, I'm not going to tell you not to laugh, but try not to, please don't heckle the shout out stuff. And use this as an opportunity when we do the debrief afterwards to pick the attorney's brains. And there's always an opportunity to take this back to your institution. They can provide material. They've offered to do this as grand rounds at institutions before, whatever you would need, and we can talk about that later. Okay, so I'll get off and look.
Good morning, Dr. Quo. I represent the family of Chad Grinder, and today I'm here to take your deposition. Have you had your deposition taken before?
Yes.
So just to go over some ground rules for today, this is a question and answer session under oath. I'm here to ask you questions that you understand. If I pose to you a question that you don't understand, will you promise not to answer?
Yes.
So in other words, if you answer a question, I'm going to assume you heard me, you understood me, and you are giving me the best answer that you can under oath. Okay?
That sounds reasonable.
If at any point in time you would like to take a break for any reason whatsoever, please let us know and we will accommodate you to do so. Okay?
Will do. Thank you.
Similarly, if at any point in time you want to go back and add to an answer, modify it, change, edit, whatever you'd like to do to make that answer the best that it can be, please let us know that as well and we will accommodate you. All right?
Yes.
And the reason that these instructions are given to you is because I'm going to rely on your answers for the purposes of our trial, which is scheduled for October. Okay?
Got it.
All right. Dr. Quill, what have you reviewed to prepare for your testimony here today?
I reviewed the medical record of the patient's emergency room visit on the day that I saw them.
All right. At that time, can you tell us, please, who was your employer?
The hospital system?
All right. And were you acting within the course and scope of your employment as you provided your care?
As an emergency physician, the scope of my practice is agreed upon by myself and my employer when I get credentialing at the hospital.
All right. So, do you remember Mr. Grinder?
I do not.
Can we then conclude that your testimony today will be given based upon what is contained in the medical record?
Based upon the medical record and my common practice patterns that I can discern from the record itself.
Okay. So we will be talking about the record then and your custom and routine as an emergency room provider.
Well, I hesitate to use custom and routine as I feel that providing medical care to patients is more of it's not necessarily concrete. There's a lot of gray area. It's not always black and white, and so I treat these patients based upon the education that was provided to me as an emergency physician completing residency and such.
So because you have no memory of Mr. Grinder, what I want to establish is what you will be relying upon to provide your testimony today. One is the medical record.
Correct.
And two, I take it, would be what you would do typically in your day in, day out practice for your patients. Is that fair?
Yes, based upon education provided to me during the course of my residency.
Terrific. In the medical record that you have reviewed, I see that you consulted with a neurologist.
That is correct.
Now, from what I can tell from the records, and please correct me if I'm wrong, this was a verbal consultation that occurred?
As far as I can tell from the medical record and my documentation, it appears that this was, in fact, a phone conversation between myself and the neurologist, Dr. Jackson.
And you provided to Dr. Jackson your interpretation of the findings on CT and MRI, true?
Based upon the medical record, I believe that what I did was I spoke to Dr. Jackson on the phone after having fully evaluated the patient and examined them along with a head CT. And then during the course of that discussion, Dr. Jackson requested that I order an MRI.
And what you told Dr. Jackson about the MRI is that there were 2 pontine T2 lesions. Am I accurate about that?
There's no specific documentation to the content of our discussion. I did reference that I spoke to Dr. Jackson about the findings of the MRI, and so it is my common practice to not only discuss my interpretation of the MRI itself, but also to actually provide them verbatim with what the radiologist is reporting.
According to your note, your documentation, your takeaway from the head CT was that it was normal, true?
Yes.
And your takeaway from the MRI was that there were 2 pontine T2 lesions, true?
Yes.
All right. Now, Chad Grinder presented to the hospital as a 27-year-old with the worst headache of his life. Is that accurate? And if I can reference you to the nurse's notes.
Yeah, so I did not specifically document that in my note. However, in the patient, in the triage note, the triage nurse does indicate that the patient reported that it was the worst headache of their life.
And it is your responsibility to review the notes that precede you from triage and the nurses, as well as the vital signs that are taken prior to your encounter with the patient, true?
It's my common practice to read the triage note as well as review the vital signs and any other pertinent information prior to walking into the room, yes.
Not only is it your practice, but the standard of care requires you to do that, true?
I'm not sure that there's actually a documented standard of care that would indicate that I must review triage notes and vital signs prior to walking into the room. I'll give you an example. A patient who's critically ill with a time-sensitive issue and I'm pulled into the room by the nurse, I clearly will not have time to review the triage note and or the vital signs prior to walking into the room at that point.
For a patient who's not critically ill, not in extremis, you would, and a reasonably prudent physician would, review what precedes him or her in the documentation, triage, nurse's note, vital signs. True?
I can only speak for my practice. That is what I do, yes.
So then you would have known by custom and routine that when Chad Grinder presented to you for evaluation and assessment, he had the worst headache of his life.
Without having any recollection of this patient, I do not know that I can say that that was a piece of information that I had at that point.
By custom and routine, however, that's a piece of information you would have had.
Objection. You can answer.
Based upon my common practice patterns, perhaps I would have known that if that were already documented in the triage note, yes.
It's actually not a perhaps, Dr. Quo. You just told us that by custom and routine, you would avail yourself of the information that preceded you in a non-critical patient. Drew?
Objection. This represents his testimony.
Routinely, I will review the triage note and the vital signs.
Terrific.
In this particular case, I cannot say that I wasn't pulled into the room and or that I did not see the patient prior to reading the triage note.
All right. Is there anything about Chad Grinder that would have had you deviate from your routine?
Not that I can see from the medical
Terrific.
record.
So you would have known he had the worst headache of his life, right?
I do not have a recollection of this patient, so I can't say that one way or the other.
Well, I understand that you don't have a recollection. I'm going by custom and routine. You would have known he had the worst headache of his life. True?
Objection. Asked and
What
answered.
is the objection?
It's ask and answer, counsel.
That's
Just
not
because
a
you don't like
legitimate
the answer
objection.
doesn't mean you get to ask it again.
By custom and routine, you would have known he had the worst headache of his life. True?
I would say that
True.
my practice habits being such, I would expect that I would have known that. Yeah.
Terrific. And you also would have known, based on the triage nurse and your own examination, that Chad Grinder had left shoulder and leg numbness since the day prior. True?
Reviewing the medical record, the triage nurse does indicate that the patient reported such. However, in my documentation, I specifically asked about numbness. I also evaluated the patient from a neurological perspective and did not find any sensory deficits during the course of my exam.
You noted that the patient had left arm and leg weakness for a day. True?
Yes.
Doctor, can you please tell me where you documented your neurologic exam?
It's in the physical exam portion of my documentation.
And please point that out to me. What verbiage you used to document your neurologic exam?
I'll read it to you. Neuro/psych: alert, oriented ×3, mood/affect normal, normal speech, cranial nerves normal, cranial nerves normal as tested, no sensory deficit, motor questionable 4 out of 5 in the left hand, arm, and leg.
So he had a deficit, a motor deficit in his left hand, arm, and leg. True?
According to my documentation,
All right.
yes.
So thus far, we've established this is a patient with the worst headache of his life. The nurse documented left shoulder and leg numbness. You documented a motor deficit in the left hand, arm, and leg. True?
Correct.
Where does the triage nurse indicate that the patient's headache was occurring?
Well, in the initial vital signs, the patient has pain. On the pain scale, they rated it a 7 out of 10.
And does she indicate it's in the posterior head?
The triage nurse does, yes.
And she indicated that on the left, the hand grip was less than on the right, and that the left foot push-pull was less than on the right.
That is correct.
All right. So thus far, based upon the documentation, we know that you have a patient who has the worst headache of his life, who has, according to the triage nurse, left shoulder and leg numbness, and according to you, a motor deficit, whose pain is in the posterior head. Have I summarized that correctly?
As a summation of the triage note, as well as my documentation, that is accurate.
All right. Doctor, what are the signs and symptoms of a posterior stroke?
There are many. At times, patients can have ataxia or dizziness, difficulty walking. They can have some visual changes, headaches.
Is headaches one of them? One of the signs or symptoms?
It can be, yes.
How about nausea?
Yes.
How
it
about
can.
vomiting?
Yes. it
How
can.
about one-sided arm weakness?
That's a little bit more difficult to discern, but, because routinely with posterior fossa intracranial pathology, you're going to have other symptoms more so than weakness in unilaterally.
Is weakness one of them?
It can be.
Okay. How about leg weakness?
It can be.
Did Mr. Grinder have nausea?
Yes.
Did he have vomiting?
Yes.
Did he have a headache?
Yes.
Did he have one-sided arm weakness?
Yes.
Did he have one-sided leg weakness?
Yes.
Was stroke on your differential for this patient?
Although I do not specifically document a differential diagnosis, reviewing my medical record that I documented and understanding the workup that I ordered, I believe that a stroke was on my differential, yes.
And how did you rule that out?
Initially, with my physical exam, through the history I took from the patient as well as the physical exam, I believe that stroke was on my differential, and so therefore I ordered a head CT and then spoke to the neurologist on call.
And how did you then rule out this diagnosis that was on your differential?
MRI.
All right. So we go back to where the questioning started, which is the MRI, and your takeaway from that MRI, as you've already testified, is that there were 2 lesions.
2 pontine T2 lesions, correct?
And that is what you would have communicated to the neurologist.
Yes.
All right. Do you have available to you in the emergency room the capability to call the neurologist to the bedside to evaluate your patient?
We do, yes.
And if you call the neurologist, your expectation then would be, if you ask for him to come to the bedside, for him to present and evaluate the patient. True?
At times, yes.
All right. Now, if we actually read the MRI report, Dr. Quo, there are not 2 lesions in the pontine region of T2. To the contrary, there is an increased T2 signal, a hyperdensity. True?
The ill-defined areas of increased T2 signal, correct?
All right. And that is different from a lesion or 2 lesions in the pontine region of the brain, correct?
Well, I mean, saying that there are lesions just simply implies that there are abnormalities noted, and it's very vague.
And to avoid that vagueness, what the takeaway should be from this MRI is focal increased T2 signal within the right body of the pons and questionably within the left aspect of the pontine body. True?
That was the impression documented by the radiologist, yes.
All right. And we don't know what the neurologist would have done had you communicated this information. True?
As I mentioned before, as part of my common practice, I would have read the impression that the radiologist documented verbatim to the neurologist.
Right. So if the neurologist then failed to act on this information about a hyperdensity, then he would have breached the standard of care. True?
Not being trained as a neurologist, I cannot speak on behalf of the neurologist from a standard of care perspective, but I will say that the MRI itself didn't clearly indicate that there was an acute process ongoing.
An MRI is not the test of choice or the gold standard for evaluating a stroke that is evolving. True?
Well, it is one imaging modality that can be utilized.
Not for an acute stroke, though. Isn't that accurate?
It can be. You can utilize an MRI in the acute stroke setting.
Isn't it true, doctor, that what you would want are diffusion-weighted images on an MRI to evaluate a stroke?
As one possible imaging modality to evaluate for an acute stroke, yes.
There were no diffusion-weighted images done in this case, true?
Not that I can discern from the documentation.
So what we can conclude then is that you, as an emergency room physician calling upon a consultant, would expect that that consultant would do what a reasonably prudent consultant would do in that circumstance. Is that fair?
As physicians, we all swear an oath, and one can only hope that your colleagues all practice in a principled manner, taking the patient's best interest into account.
No doubt. And you swear that oath too, don't you, doctor?
I have indeed.
And this impression specifically indicates that clinical correlation is required for this study. True?
As with every radiology read, yes.
Absolutely. So, swearing your oath to this patient, you would have certainly considered that he had the worst headache of his life, left-sided weakness, left-sided numbness. True?
According to the documentation, that is correct.
Nausea and vomiting. True?
Yes.
And so for this patient, doctor, as he walked out the doors, you knew that stroke remained on his differential, didn't you?
Well, again, without having documented a differential diagnosis, I can only say that looking at the documentation and the workup that was performed, I think that my differential diagnosis was actually quite broad. And having a CT scan that showed nothing acute and an MRI that didn't show anything in particular that would have been overly concerning for an acute embolic stroke or intracranial hemorrhage, I can only assume this, but through my documentation, I would imagine that I thought that the patient was having a complicated migraine.
The one type of stroke you failed to include in your answer is an ischemic stroke.
Well, that's what I meant by an embolic stroke.
And you're relying then upon the MRI and the CT scan to conclude that Chad Grinder did not have a stroke. Do I understand your testimony correctly?
Partially. I also rely on my own evaluation of the patient as well as the neurologist's recommendations when I discussed it with him.
Good.
We're going to stop it there. So Dr. Quo. I've known Jeff from a long time, and it's fun to watch him squirm a little bit. So So the last part of this is going to be the debrief. So we have two very experienced attorneys here that you get to ask them all the questions that you never get to ask them, or you probably should ask your own counsel, but you now have this opportunity here. And we're going to let them sort of debrief how Dr. Quo did, so, and maybe ask Dr. Quo how he thinks he did also.
So I do want to give you some background on the case. This is an actual case that proceeded to trial. The neurologist was in the case as a defendant. There was finger pointing on both sides, which is an interesting issue that I'd love for you guys to ask questions about, what that can cause in a case. The neurologist settled before trial, and the emergency room physician received a defense verdict. But that is one piece of the puzzle that you can't discern from our inquiry here today.
And one effect that would have been in a real-life situation, because the neurologist was in the case at the time of deposition, there are questions that they directed at him that the neurologist defense attorney would have jumped up and down about. But I didn't represent the neurologist. I represented Dr. Quo. So there were times you would have heard other objections to questions, but because they weren't directed to him and his work, you just didn't hear them today.
And I'll say that despite the fact that this was not my case, having reviewed the documentation, I knew I was going to get crucified. And, oh yeah, absolutely. And during our prepping sessions, it was pretty obvious. And I will say that in the end, the way that I feel about it is that I always try to not get trapped, right? And when Marilena starts asking about standard of care and things of that nature, if you agree to a standard of care, then you're trapped at that point. And it's, well, wait, if you didn't do this, then you have deviated from the standard of care. And so I try never to agree to that and always fall back on my education as a board-certified emergency medicine physician.
Yep.
This patient got discharged. As far as you can tell from the documentation, actually what happened was the neurologist said, order this MRI, at which point the ED physician did so and then called the neurologist back with the results, which is something that we all do as the ER physicians.
I think there was a fair amount of turf battle in the real case, right, between neurology, radiology, and emergency medicine.
So from a practical perspective, what happens behind the scenes sadly really has nothing to do with the defendant. There are policies of insurance that provide coverage. Some insurance with the insurance comes a consent clause where you have to consent to settle. Some don't have a consent clause. But behind the scenes, what goes on is a battle of who's paying what and who has a consent clause and who doesn't. So in our particular case, in this case, the emergency room physician did have a consent clause, did not consent to settle. The neurologist, whether or not he had a consent clause, I don't know, but they did settle. Whether or not he consented or didn't consent, I don't know. But it left open the empty chair for the emergency room physician to say, I relied upon the neurologist. Now, had the case gone to trial with the neurologist there, it would have been an easy plaintiff's verdict because the plaintiff's lawyer would have had the opportunity to stand and say, there was negligence, don't take my word for it. He says it was the neurologist says it's the emergency room doc. We say it's both, but we leave it to you to decide. It's not an issue of was there negligence, it's an issue of who, and we say both, right? So there was benefit, abundant benefit to the emergency room physician to have that neurologist settle the case and still be allowed to talk about the negligence of that neurologist. I don't know what your state's definition is, but standard of care typically is what a reasonable and prudent emergency room physician would do under like or similar circumstances. What sets the standard of care is practice, custom, routine, literature, experts. Remember, folks, if there's no expert to testify against you, there's no case, right? So that's why there's still malpractice, because there are times when there is a deviation from that standard of care, and an expert will testify as to what that deviation is.
You know, in the state of Louisiana, we've had significant tort reform, and we are actually it's actually very beneficial to us as physicians. And we have a 3-person review panel that is comprised of folks that practice in your field. And what I tell my residents is we live in an academia world where we are always up to date with the most current literature. However, if I'm getting sued by a patient and the 3-person review panel is comprised of physicians from small town Louisiana, I'm from New Orleans, small town Louisiana, where they've been doing the same thing for 25 years, their standard of care may be different than my standard of care. And so what I will refer, whenever I'm documenting things that I know are really more progressive and as I mentioned, up to date with the most current literature, I will specify that. You know, I'll say things like, according to the most recent recommendations by the American College of Emergency Physicians or something, when I know that other doctors 200 miles outside of New Orleans will have no idea why I did what I did.
There's a question over here. Yeah.
Was there a change in the radiologist read? It seems that from the initial read, was there like a preliminary read and then changed? Is that
No.
final read?
Final read. Now, at the time, I was representing the emergency room physician. We did send the films out for review. And there was a question as to whether or not this review was entirely accurate. Having said that, we don't want to complicate matters. Plaintiff did not bring the radiologist into the case, so we weren't going to do that.
So as for the attorneys, so as the plaintiff's attorney, what did you like that Jeff did? And as the defense, what did you like that Jeff did? I guess you want to critique his performance.
Or didn't like it.
Yeah, exactly.
Go ahead,
So,
Denise.
I mean, they're on opposite sides here, so.
Right. Well, and certainly one of the general rules in this type of situation is you all are the doctors. You all have the education, training, and experience. And you'll have a lawyer sitting there next to you defending you. But the person on the other side, the Maralenas of the world, are going to know some medicine. She knows a lot because she was a nurse before she was a lawyer. But you'll have some people who only know a little bit of it, or they've gotten some phrases from their expert that they're just going to try to make it sound like they know it. You all have to trust what you know, what you've got in your experience, and the confidence you have in your abilities. And we've done this a couple different times. And I think at least once today, he went back to relying on my education, training, and experience. You work with what you have. And one thing I thought she might come up with, but she didn't, that triage note was written after he saw this patient. So she kept going down that line about, well, you would have known this, you would have known this. Well, in this situation, I don't think they did, because that note hadn't been written yet. So then we hark back to the importance of charting and timely charting. But we all know if you're faced with a critical patient and then your other option is go write a note on something else, you are going to have to deal with a critical patient. And there's always going to be notes that get put in after. But know the chart, know the documentation in that chart and the people who work with you and around you. If you know the triage nurse is one of the best in the world and that you can fully rely on them, you just serve that right up and say that. And he did a really nice job of just taking it all back to what he did. He didn't need to know what her triage note says necessarily because he saw the patient sitting in front of him. And the guy didn't say he had the worst headache in the world to him. Said it to the triage note, triage nurse, which didn't get noted for another couple hours. She also didn't, question some of the medications. We had kind of an abbreviated time today, but there were other issues in this chart that could have been of great fun for a plaintiff to talk about when you order something stat and it doesn't get administered for 4 hours. That's sometimes pretty uncomfortable for you to try to explain. And we went over how we were going to explain that, and then she didn't do it, so that's kind of no fun.
Really interesting point about the timing of documentation, and in my own practice where I routinely will write my provider note a day or multiple days later, and it's happened whereby she brings that timeline, patient complaint brought to my attention, that they feel that X, Y, or Z wasn't done right, or something could be. So then I'm in a position of having that know, plus I'm going to write my initial provider note. So which could be, I can see both from a place of your note now is going to be not trusted, or I can see it from the point of I now have the opportunity to really make sure I document really well, knowing that there is a problem. So how should I look at that?
Well, I think you have to chart it all, but you can identify the sources and the timing of this additional information. I mean,
All, not in addition, it's just the information. When it comes to like days later,
okay. Well, you got to chart it when you get it. I mean, I don't know why it would be days later that you're getting it, but I can imagine there must be a situation if you bring that question up. But you have to chart it when you can, and if you don't have the information before that, you can't chart it. But I would question why you can't go out and get the information to chart it.
We've all had those cases, right, where you got busy, you didn't chart till 3 days later, and then someone said, "Oh, did you hear about that patient?" or something like that. So I think
then it
that's kind of what
influences your note.
he's talking about. So I mean, those are the worst words you hear walking to a shift. Oh, you remember that patient, right? So
I'm trying to figure out by waiting multiple days later, just because that's there. Am I setting myself for more legal risk? Because then they can say, we can't trust any of what you wrote because all this was written after you knew this was possible.
Trust me that any plaintiff lawyer will take advantage of that.
yeah.
The notion that there has been a delay in documentation, even if it's a totally legitimate reason, you got so busy, you didn't have an opportunity to document, if it's an unexpected bad outcome, a lawyer will absolutely take advantage of that to suggest that there was a purposeful delay in documentation, that you sort of ruminated over what to document to allow yourself the best defense possible, even though your intentions are all well and good. Sometimes it's going to happen. I don't think that you can insulate yourself 100% from liability. But remember, at the end of the day, if there is no expert to support the case, there is no case. So will it rise or fall on the issue of documentation? Probably not. But if there is a case to pursue, the issue of documentation makes it that much more sexy, because now you have a cover-up, right? Even though it wasn't. So in and of itself, late documentation isn't an issue unless there's a legit bad outcome with something to question on the issue of standard of care. And then documentation takes that case to a whole new level. My one piece of advice, if you take away nothing else from today, do not ever, 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 ever change or alter your documentation. That will put you at personal risk, because that conduct can be determined to be punitive conduct if you are doing it in anticipation of litigation, which is a fact question, if you are covering up intentionally. And that opens you up to personal risk because your insurance doesn't cover punitive conduct. So no matter how much you might want to go back after you hear about a bad outcome and explain or edit or amend, don't do it. Don't do it, and don't do it. Unless you have a legitimate chart issue where you say late entry note and you do it all above board. But if you go back and try to alter that documentation, trust me, an audit trail will pick it up. If you still have paper charting, it will get picked up, so don't do it.
I think a lot of us would, like after where you get that sort of sense that something bad is going on, you go and you write the more eloquent note than you usually do, and you do it right away. The problem is that when you end up getting a suit, it's sort of like a surprise. It's not the one that you were expecting. It's the whole like I've committed malpractice, I've been sued, I've just never been sued for malpractice.
What's the realistic timeline of all of this case, from the time of subpoena to the time of whatever?
Great question. In Ohio, that timeline is about 18 months to 2 years. The Supreme Court rules of your state will determine how long a judge can have a case pending, a civil matter pending, but it can be from 18 months to 2 years.
I was actually just deposed a couple of weeks ago on a case that was from 2014.
Statute of limitations in Ohio is 1 year for medical malpractice, 2 years for wrongful death.
Yeah, the one that I was just deposed in, they filed within 365 days, which is also the state of Louisiana, but it just has taken this long.
And the more defendants that you have, the longer that it takes, simply pragmatically from a calendar perspective, trying to line up everybody's availability to conduct the various depositions that need to be conducted. But the judge does set a litigation schedule in all jurisdictions where certain things need to be done by certain deadlines. That being said, there are typically 1, 2 continuances in a case that can happen for reasons that are totally benign, scheduling issues.
Is there some kind of exception where it's not just the time of the occurrence, but when you sort of discover, maybe?
That's a great point. In Ohio, we have a 1-year statute of limitations for medical malpractice. That 1-year statute of limitation, except for minor, but there are no OBs in the room, so you don't have to worry. But for an adult, it is 1 year. Now, that 1 year is from the date of the discovery of the negligence or the date of the last treatment with the physician, whichever comes later. You guys typically see the patient one contact. Having said that, I do have a case right now where the same emergency room provider saw the patient 3 days in a row. That's neither here nor there. So from the date of discovery of injury. With that in mind, and it's likely not to come up in your cases because emergency room cases, typically the date of discovery of injury is within days of that visit. MIs, strokes, so it's at or around the time that you provided the care. I'm talking about Ohio's 1 year. I don't know other jurisdictions. In Ohio, we have something called a statute of repose, and that means that even though you have this 1 year from the date of discovery of injury, it cannot be more than 4 years out. You are forever precluded, which is really an issue for folks who have late diagnosis of cancer. But for you guys, typically that discovery date is going to be very close to when you saw the patient, because most ER cases are indeed stroke, MI. Those are your 2 big ones.
Heard that documentation, it's better to write, differential, MI. However, I feel this is patient very low risk, or CDM likely. That's better when the patient comes up and goes out of heart attack. That's actually better protected than if you don't write that. That physicians are allowed to miss things, or not allowed to not think of things, or consider things that are reasonable.
So obviously, if you're in a situation where a lawsuit happens on a missed MI and you have that in the chart, that is helpful, for sure. Having said that, it's also fodder for cross-examination on, well, obviously you were wrong, kind of thing. Now, your best defense really is your custom, your routine, your judgment, your analysis, and it can be, of course I considered MI. I got labs, whatever your decision-making process is. Sadly, even if you write it all down, if somebody walks out and has an MI, in all likelihood you are going to get sued. That is just the reality.
Yeah, I don't list the differential in my note because in my mind it can only hurt you. I mean, if you list it's not an MI, just like you said, and they end up having a cardiac event, it's not really going to help you that you thought about it. I always taught residents, your job is sort of the dummy thing is to find the typical presentations of common things. So if someone comes in crushing, radiating chest pain, you should probably think about that. The atypical presentations of common things. And the reason you went to medical school and stuff, the typical presentations of rare things. You're not morally so medically obligated to find the atypical presentations of rare things. I mean, those are the things you're gonna miss. But I mean, she could still trap you.
And just remember, the jury roots for you. Jurors appreciate and respect, just as we do, what you do day in and day out. I can go to medical school. I respect the heck out of you for doing what you do day in and day out. You go and save people's lives. Jurors understand that. And you do get an implied benefit of the doubt from that, because the folks who are sitting and listening to the evidence do not have the knowledge, the wherewithal, or the commitment that you do to saving people's lives.
I think you might have answered this, but I want to just make sure. When you were going through the deposition, at the beginning establishing whether or not you remember the patient, there were a series of questions there about how he didn't remember the patient. He had to keep saying that. So, although that's very common, right, the fact that you were asking so many questions, was that to establish that he had to rely on
Yes.
common routine practice?
Yes.
It made it sound horrible, like, how can you not remember this patient?
Yes.
Like, you should be
Thousands of people.
Yeah, so for an emergency room physician, let's be truthful, you're not going to remember the patient. But as the lawyer, I need to establish where his testimony is coming from so that he doesn't show up at trial with a new memory, and if he does show up at trial with a new memory, great, now I get to cross-examine him on this new memory that evolved after the lawsuit and after the deposition. There are certain times where not remembering the patient is a huge detriment. For example, if there is, I will give you the one I can think of that doesn't apply to you, but you can apply it by analogy. Maternal deaths. Maternal deaths, particularly from a postpartum hemorrhage, that are so infrequent, if you don't remember that, that's weird. Particularly when you say, I've never seen it before, this is the only time, but I don't remember it. Right? So there are circumstances where it's such an unusual presentation, one that you've not encountered, that you, as a plaintiff lawyer, can really undermine somebody's credibility for saying she exsanguinated, but I don't remember. In the case of an emergency room physician's practice, it's really not a big deal not to remember. So my purpose in doing that was to establish where the testimony is coming from and to not be caught blindsided at the time of trial. Like, I have a job to do, and if I don't ask that question, he can absolutely come to trial and say, you know what, I know this patient, I remember everything. This is a conversation I had. So we want to establish, where is this coming from?
Back to the differential conversation, because I've been taught that to protect the right of differential, like you're taught that maybe you're opening yourself up to risk. So I'm just maybe, just based on your experience, do you find that when people write a differential, they end up protecting it, does it depend on the quality of the differential, is there any advice? Maybe not people, might be good or your experience.
So I happen to agree with Mike. If you write something down and then it evolves, right, I get to use the following phrase: you were wrong, you were wrong, you were wrong, you were wrong. Now, even if you don't write it down and you tell me verbally it's in your differential, I get to say, you were wrong, you were wrong, you were wrong. So I tend to think, go by custom and routine of what your differential likely was for this particular patient and do it that way, rather than document, because your differential can be so extensive. And then if something happens that's not on that differential that you write, then I can say, you were wrong, you didn't include this, you didn't rule it out. Now I can really cross-examine you on what's not there. So to surgeons, I say, please document the following: risks, benefits, and alternatives discussed, questions answered, patient agrees to proceed. Do not write all the risks and alternatives, because in all likelihood you will fail to document one of them.
Right.
Same with the differential. You have a great thought to start by writing your differential, but what if you didn't include something? So go by custom and routine.
So just, if you don't mind, so what would be that ideal thing? You said that the surgeon wants to write that. What
Right.
would be an ideal ED provider thing?
What would you typically write if you weren't including your differential? Assessment plan, your assessment and your plan.
Yeah, so I might write, you know, so it's going to put the abdominal, maybe I'll just write then like high morbidity abdominal complaints considered patient seems unlikely to have.
Perfect. Perfect.
I think it's a challenge because then you send that chart to the coders sometimes. And
Oh, see, and that,
yeah, exactly.
yeah, sorry, I forget about that because that's not my world. I forget about that. I will tell you though, what's the term? Dyskinesia
Yeah.
for belly pain? What is that word? No, I don't have it right.
Dyspepsia?
No. Forget it.
Just like gastritis or something like that.
There was something that can lead to, when you use a really big umbrella term, I know you have to do it for billing purposes,
Right.
but that too could be an issue. But you cannot insulate yourself.
Yeah.
You only can do the best that you can do.
Which I think is also kind of the benefit of this exercise. I mean, you're probably going to get sued. So I've been sued multiple times. And you're going to get named. So it's going to happen. And yeah, you can do all those things to prepare. And just like Mike said, it's never the case you think you're going to get named on, right? And so, and then getting to the point of doing an exercise like this, you know, if you guys are in residencies, I took this to my residents, and you know, I had some local council depose our residents, and I mean, it was one of our best conferences ever. Like we ran it for 90 minutes and ran out of time. And like these types of exercises on how to conduct yourself during a deposition, because it's going to happen. It doesn't matter what you're out of the chart, patients still sue you, right? So you get the best chart ever, still get sued.
You cannot win your case at deposition. If you've gotten to the point of a deposition, this lawyer's not going to pack up and go home and say, okay, you convinced me, but you can lose. And that is why I always say, no matter what, make sure your lawyer prepares you. Make sure you meet with your lawyer. And if you're not comfortable after session 1, say, I need session 2. Or I want somebody to mock cross-examine me from your law firm. Because typically by this point in time, you're working together, your lawyer does not intimidate you, you're pals, and you know, you're in it. Get somebody else from their law firm who will intimidate you to sit down and conduct a mock exercise. Because you can't win at depo, but trust me, you can lose.
Right, and that's exactly it. It might
Just
take
a
you
question here,
3 or
please.
4 prep sessions before you're comfortable and okay with the process. Doesn't mean something's not going to throw you during deposition, but you'll have your counsel sitting there. One thing is, there are only limited times as a defense lawyer I can object. I mean, there are a lot of things that sound objectionable, but legally they're not. And so we just have to make sure you all are comfortable with the phrase they're going to use, and the worst headache of his life. How, you know, she used that a lot because it's, you know, it's, oh my God, the guy had the worst headache of his life, and you know, I let him go home. So you get, I don't want to say desensitized to it, but it becomes more comfortable, and you become more confident in what you've done. You know the chart. You've asked all the questions that you had. There will be more questions, so call and ask. You know, you might have to go to your legal department first or call directly to your defense lawyer, and they should always sit down as much as you want. And I always do have one of my partners will do a cross-examination, and they're coming in with a more limited knowledge of the problem and the records and the medical issues, but they're good at twisting and, you know, getting you to agree with something that you never thought you'd agree to. A couple of times, I mean, I objected because she kept asking the same thing 2 or 3 times, you know, and I'll say, just because you don't get the answer you want doesn't mean you get to ask it again and again and again. You guys know the answers. You guys know the medicine. We're just lawyers, so trust yourself.
At one point, I failed to comment on what Denise said about the triage nurse. There's 2 things that can happen in this particular case. You either run from the medical records or you embrace them. If you run from the medical records, it is worse than if you embrace them, because you either knew what the triage nurse wrote or should have known. She either should have written it timely or she should have told you that by way of verbal report. And trust me, if you depose that nurse, she's going to say that she gave you that information. So you have to embrace it. Your charting should always be something you embrace, not run from. Because if you're running from your charting, therein begins the first problem. So it might not all be there, but you can fill in the blanks with custom and routine. And everybody know, you can't tell me you brushed your teeth May 13th, 2015, but by custom and routine you sure did. So you can rely on those things.
Probably the last question, unless they forget to kick us out.
I can certainly ask somebody afterwards, but so my institution has started mandating the inclusion of certain evidence-based decision rules in our documentation. Specifically, what they're doing right now is they want us to document a heart score on any patient that gets an EKG instrument in order to justify sort of our risk assessment. I was curious, from your perspective, what you think of that, given the conversation about differentials, because obviously that addresses one piece of the chest pain chart, but only that one piece.
So what do you write?
So we actually, within the electronic health record we use, there is a calculator button. You click on the calculator, and it allows you to input a point score for each of the pieces of the, I don't know if you're familiar with heart score. It's an evidence-based decision tool that evaluates your risk of major adverse cardiac outcome, and I think it's 30 days after a ED workup for chest pain. It's based on history, EKGs would come in, and risk factors would age, essentially. And 0 to 3 is supposed to be low risk. You go home. 3 to 6 is like observation. I can't remember the exact numbers, but and so this will automatically populate our chart with that information.
So if I'm defending you, I take that information and I say, Dr. Brilliance acted according to our own practices and guidelines, and inherently in what you just said, you obtained an EKG and troponins. Yay. I mean, right, because typically these cases arise from not getting the EKG or not getting the troponins and going home with that gastric cocktail. So I like the idea very much, because it's not you writing, this is what I was thinking, it is you complying with your hospital's own policies and procedures. Anytime a defense lawyer can stand up and use words like comply, followed, by the book, by the letter, by the policy, those are good things to say out loud. They are good things. If you yourself, however, were writing a list of differentials, you limit yourself in by the book or following, because you might leave out something. I can't give you a scenario, but that sounds like a pretty nice road that they have incorporated for you.
On the flip side of that, so what if the physician doesn't document the heart score, but there is an email chain somewhere or a policy somewhere in the book that says you're supposed to document?
That's a big problem. Right. That's a big, if you don't document it and your institution says you're supposed to document it, that's a free-for-all, right? Because now you've violated your own institution's policies and procedures, and some pretty good lawyers can actually use that in deposition and catch you off guard and say, as part of your employment, you're supposed to follow the policies and procedures. That now you've breached your obligations as an employee, and it can snowball. If it's a policy in your institution, you got to follow it.
I think
Oh, sorry.
we have to leave. So
Okay.
Thank you, guys. Thanks.
Thank you.
Thank you.